Hey guys, it's your girl, Crystal Nicole. So you guys know we are all here to discuss the DA's response to Tory Lanez's motion for a new trial. And I have to say that I am just disappointed in this lackluster effort at a rebuttal. But I'm really not that surprised because I figured they wouldn't have much to say after that 84-page discovery of a total miscarriage of justice that went down in that courtroom. I'd probably only have an 18-page rebuttal too, even less, but I digress. Let's go ahead and get into it. So let's start with the Kelsey post that they assumed had been made by Tory Lanez saying that's not true. The DA does not want to admit that there was an actionable delay in entering this post, although there was, as they had the detective investigating this post during trial, but not beforehand. So their argument is that, they did nothing wrong by entering this when they did because the defense knew about it for 2 years and didn't provide a defense to it. So here's the problem with this. They defeat their own argument because the DA also never bothered to even look into this post until trial started. So they also waited 2 years to care anything about it or do an investigation into it until trial. And the investigation they did into it was shoddy because they never even discovered if Tory had been logged into his account when that comment was made. And they admit that they only threw it into the middle of trial because the defense was saying Kelsey was the shooter. And they assumed Tory had wrote it when they did, which is the problem. That makes that hearsay evidence, which is inadmissible in California. You can't just think. You have to know before you enter things as evidence. On top of that, if they did not enter this in as evidence during the discovery phase, why would they just expect Tory's team to have a defense to something that they never cared about until trial? It's a double negative, and this argument does not work. So they move on to LILJU made the beats post. They claim that this was not presented for the truth of the matter and that Tory's team never objected to this post being entered, which I find very hard to believe. And they admit it may have been an error in presenting it, but this error didn't add to his conviction as it wasn't the evidence that put him away. Then they go on to list the 3 things that put him away. So they claim that there was multiple eyewitnesses. Who? They said the gun was found where he had been sitting at. Okay, all 3 individuals had been in that seat at one time, and Megan and Kelsey were the ones who was in that seat when the shots were fired. So how did we just naturally assume it was his with that information? 3, they claimed that he apologized from jail. So let's go ahead and kill this nonsense right here. Without the admission of guilt following the apology, you do not have an admission of guilt. If there would have been no need for a trial because we would have clearly heard Tory on tape saying, hey, man, I'm so sorry that I shot her. I shouldn't have did that, man. I was just so upset because she was insulting my music career. But that doesn't explain why I shot her. I shouldn't have shot her. How many times did y'all hear him admit to actually shooting Megan during that call? Unless you actually heard an admission of guilt, there wasn't any. So this was not proof of him doing anything besides apologizing for something. That's all we got. And this is a problem because, for one, they entered in hearsay evidence just to have it there, but not because it had any truth to it, as they just admitted. That post said that the gun belonged to Tory and that the bullets were matched from her feet to it. But you think this had nothing to do with him being found guilty, even though we are at a trial about him allegedly shooting Megan? Seriously. Okay, if we want to play stupid, that's cool, but it won't work. If you knew there was no truth to those statements, why was it even entered as evidence in the first place? Especially since you had no evidence of what the post said to even make it relevant. That's a major error, and I highly doubt that it's just going to be overlooked. So moving on to the statement Megan had made about Tory claiming that he was on probation and trying to buy her silence, etc. The DA claims that they did not err in entering in the statements that he said he was on probation, and they're claiming that they could enter it not for the truth of the matter, but because Megan said it. And Tory lied to her just to get her to not say anything. So here's the problem with this. During the preliminary hearing in December of 2020, 2 years before trial, the detective was asked about this statement Megan gave about Tory being on probation, etc. And he said that he investigated it and found out that there was no truth to it. So the DA definitely made an error presenting it, as they should have known from that hearing there was no truth to those statements before they brought it up again during trial as if they didn't know. And claiming that Megan saying it was enough to enter it is not a good enough reason at all, since she had turned out not to be a credible victim since they had been pulled over and questioned that night. Her story changed multiple times and she was dishonest, which the detective also admitted to during that same hearing while speaking about her claims about probation. You also cannot just assert that even if he wasn't on probation, he said what he thought would make them stay silent. That is also hearsay and speculation, as you have no proof to back up those statements. And seeing as how the DA had such an issue with alleged hearsay coming from Sean Hawley during that same preliminary hearing, it's interesting that they now see no problem with everything they did during trial and even in this motion. So Sean Hawley wrote a letter January 10th explaining her absence from trial. She said it was due to another arbitration and not related to the defendant's claims, meaning she was not at trial due to another case and it had nothing to do with anything happening at his case. Now, as you notice, this letter was entered in January 10th, 2023, after the verdict had already been given out and she was no longer his attorney. We were all already aware that she was not at trial due to another case and it had nothing to do with Tory, as everyone was curious about her absence. This was also brought up in Tory's motion for a new trial, so this did not escape his attorneys by any means because they mentioned it, and that was not their issue. Sean Hawley had not stepped down as Tory's attorney before trial. She just wasn't available to defend him at his trial, but she was still representing him. It was during the middle of trial that she had to step down as his attorney due to the bribery claims being brought up in that 80-minute interview and Kelsey being questioned about it on the stand, which the letter is not addressing. And that's the problem. The issue is her having to step down as his attorney during the middle of trial, not why she wasn't at his trial. The DA seems to be confused and they may need to redo this part of their motion. If they have a letter of her addressing why she was no longer his representation and this was her response, then I would understand why this was entered, but it's not. And it's either an attempt to manipulate the court or it's an honest misunderstanding. You guys be the judge. They then go on to claim that the defense did not object to any of what Kelsey said in that recorded interview about Sean Hawley and the bribery. And this just does not make any sense to me, because you keep on saying that they didn't make any objections to the interview, but yet the interview wasn't supposed to be evidence of anything to be objected to. And they objected to the interview being played in the first place and it was denied. So at this point, the only reason why this interview was being played was to prove that y'all didn't pressure Kelsey. Remember, if they were supposed to be objecting to everything Kelsey said in this interview, then Kelsey should have still been on the stand while this interview was playing so that they could object each and every time they heard Kelsey say something, so they could question Kelsey about what she was saying. But at the time, y'all just wanted this to be played to prove one little point, right? It wasn't supposed to be evidence of anything for them to be objecting to anything, right? If that was the case, then they should have been able to confront Kelsey about it. The argument here is that their expert testified to the same thing that the defense's expert testified to, and that was that Tory's DNA was not found on the magazine of the weapon, and it was inconclusive on the actual weapon. So they don't understand what they're objecting to concerning the DNA because they made no objections during trial. Tory's team is saying that They overprocessed the DNA. They tried to manipulate the jury into believing that the DNA doesn't matter. And they tried to oversell them on the issue that they couldn't say his DNA wasn't on the weapon. They didn't make it clear to the jury that it could have been any random user on the street DNA. And that although they found female DNA on the weapon and had a female who tested positive for GSR, plus a witness who claimed he saw the flashes come from Kelsey first, they made no attempt at testing her DNA or even Megan's, only Tory. And like the defense DNA expert testified, he should have received everybody's DNA, but he only received Tory's. So they failed at doing a process of elimination to determine if anybody else besides Tory could have been responsible for handling and firing the weapon. Therein lies the issue. Not only that, but they also just outright lied and manipulated the jury with their closing statements when they said, if anybody thinks, despite the evidence, that they have a whiff of an idea that Kelsey shot around, even though Mr. Sean Kelly never says that, this trial is about what the defendant did. KelseyHarris is not on trial. It's about what the defendant did. And Sean Kelly clearly states that the defendant fired rounds at the victim. Sean Kelly at no time throughout his testimony ever said that Tory fired any rounds at Megan. He repeatedly and consistently stated that the flashes came from the girls first, and he told the police they appeared to have came from Kelsey, and that any rounds that could have came from Tory were fired into the air everywhere. But never does he have Tory pointing anything at Megan or even physically assaulting her that night. He puts all of that on Kelsey. Yet the DA intentionally lied to the jury during closing and says Sean Kelly never said Kelsey did anything and that Sean said Tory did it. Now, if that's not enough for you, remember back when DJ Academics and Mob Radio had posted about Tory's DNA evidence not being found on that weapon? They had post after post put up claiming that this was not true. It was all misinformation, just for it to be the same information revealed during trial, that his DNA was not found. So if the DA wants to go with they were not trying to manipulate and do any trickery when it came down to the DNA, they can go with that, but I don't think it's going to work. So when it comes to Kelsey's 80-minute interview, remember that the defense tried to block this ruling, calling it late discovery, but prosecutors said that it was critical considering Kelsey had backtracked on her September statements. So the DA's argument is that while Kelsey was on the stand, she was cross-examined by the defense, so Tory's rights were not violated to confront her, while failing to understand, once again, that they are talking about her 80-minute interview that was played after she was already dismissed from the stand. They were not able to confront her about the things she stated in that interview. They were able to question her while she was on the stand, and they did. They tried to get her to talk about the fight between her and Megan, and Kelsey just claims that they just bumped into each other that night. And she claims that she was just really drunk. She denied Tory had paid her anything. She said she was not afraid of Tory. She says she wasn't trying to keep herself out of this whole situation by just putting it on Tory when she did the interview with the DA. She said that Megan lied about the dance beat dance part and that was just stupid when she said it. She said Megan needed to be held accountable for all the lies that she told regarding that night. Outside of that, not much questioning could happen about her interview because they didn't know all of what she said in it. They had no transcripts when it was allowed to be played in court, and Kelsey wasn't even on the stand to be able to question her while it was being played. Furthermore, the defense objected to it being played right out the gate, but it was allowed. So exactly how did you expect them to start objecting to what was being said once that ruling was given? So they then claimed that they did not shield Tory's right to testify by using what they call impeachment evidence against him, which would be the so-called situation with August Alsina, his music video cap, or Tory lying about how tall he is, all things that they are allowed to do. However, the issue is, like with August Alsina, August never pressed charges. There is no video of the situation. There's no proof that this even happened at all for this to even be relevant to the situation. Second of all, using his music video cap is definitely not allowed because it goes against the law of the creative expression thing. And trying to use him lying about how tall he is, I mean, you can use that, but I don't think anybody would have really cared. So they just really claim that they did nothing wrong by trying to use these things to, if he testified. So Tory has every right to not allow them to try to use irrelevant things to his case, to try to dirty him up, to try to make him look guilty. So he had every right to decline to testify, given what they claimed they were going to be trying to question him about at trial. So, I mean, it is what it is there. So the image of the tattoo, they again claim that they only used this to prove his identity and also to prove who was swabbed that night, which again was only Kelsey, Tory, and Quan. They could have used any other photo to prove Tory's identity. This is just a weak argument. And then they claim that tattoos are not a part of creative expression, so it does not fit into the creative expression law, and that Tory's lawyers are attempting to try to get the judge to include something that is not really included in creative expression. And I 100% believe they are wrong, because tattoos are creative expression because they are art, which is the same thing music videos are. It's art. It's called creative expression, and art is included in that, which would also include tattoos. So I don't really understand their argument here. So last but not least, we have Tory's music video Cap. They claim that they did not violate the law by using his music video during trial because it was Megan who brought it up as a part of her victim's statement, and it was relevant due to her credibility. A credibility that had been shot during her own testimony. So this is really not a good argument to use, and I really don't know why they keep using it. You cannot keep claiming that you were allowed to enter in things based off of Megan's testimony because it went to her credibility, when Megan got caught lying about quite a few things during trial. So why do y'all keep using this? I really just don't understand. But that's really as far as that one goes, because Megan got up there and she was like, I have to watch him, in music videos chopping or butchering up horse legs, like it just doesn't make me feel good, or whatever she said. This is the reason why they thought it was okay to use his music video during trial. Like, whatever. So with that being said, this motion just frustrated me beyond belief. I really expected them to come a little harder, but really, what all could they say? This is nothing but a bunch of deflection, denial, and manipulation at its finest. That's really the best way I can explain it. And they have the nerve to accuse the defense of doing that in this motion. It's ludicrous. They are basically saying, yeah, we may have made a few errors, even though we won't contest to that, but the judge allowed it, and you guys never objected to any of our wrongdoing, and that's his previous attorney's fault. What really kills me is the evidence listed that they claim put him away. They are not even being honest about that. They did not have multiple eyewitnesses who named Tory. They had a lying victim, a witness who accused Kelsey, and Kelsey coming in giving them a different story from the victim. How does that align with multiple eyewitnesses when the eyewitnesses' accounts don't even match each other? You claim it was because the weapon was found under a seat all three had been in at one point during that night, not just Tory, to just come to the conclusion that it could have been only his and it was an unregistered weapon. It makes no sense. Then you say he apologized for it on a phone call. He never said what he was apologizing for, and had he not come out and told us that it was because he got caught smashing two best friends and caused them to fight that night, plus Sean Kelly's testimony to back that up, we would have never known it could have been for that reason either. There is more than one reason that he could have been apologizing to them. But if we focus on that second reason, it makes us focus on the other person in that car who tested positive for GSR, which makes us focus on these photos, which makes us think of this fight both women keep denying happened, which makes us wonder, well, damn, could he have really been apologizing for spilling the beans, which caused the fight to break out, which caused shots to be fired, which he felt horrible about? Because that's not his character, but that liquor had him on something else that night, and he felt like being messy since Megan had just did it to get him to leave Kylie's house. Is that not possible? They are really going to have to come better than this, because something tells me that the response to this is not going to be anything nice and will make them look more deceitful than they already do. So I'm just going to leave it at that and wait for the 10th to roll around and see what the judge does, because at this point, that's all that really matters anyway. But he does have me giving him the major side eye with all he allowed them to get away with. And with these justifications, he's going to have some major good reasons for a denial if he gives one, because I just won't get it. So, with that being said, stay tuned and free Tory.